will I not get to any emails in the next 2 to 3 weeks? I am busy with a couple of very urgent and serious instructions. So guys, please, if I don't get to your emails, I'm not trying to be funny or anything like this. And if one of your emails are urgent, I will not be able in the next 2 to 3 weeks to attend to it. So please refer it to another counsel in your local bar. All right, my apologies for that, but I'm in a situation where I can't get to all of those emails. When I finish here, I go back to my chambers and I sit until sometimes 1 o'clock in the morning, busy with instructions from that at this stage is very serious. About 2 to 3 weeks from now, all the people sending me emails, I will be available. If it can wait, then that's all right. All right, guys, welcome to the pupils too. The pupils for the advocate coming up advocate exam in September. The guys becoming advocates. Also, welcome to this presentation that will start in about 3 minutes. This will be made available to you, and you won't see this in real time. All right. So we've got about less than 3 minutes to go there. That's all I can think of about now. Please, there in the back, put off your cameras, mute. I can hear a parakeet, a parrot. Parakeet. Somebody has got a bird in the back. We had the same problem last week. And we thought it was our equipment, but you can clearly hear it's a parakeet or a parrot or something. Please mute on your side and put your cameras off. Another thing I just want to announce is if you are not legally entitled to be on this link, please remove yourself. We have operators. The moment this starts, 12 o'clock, we have operators that monitors who is legally on the link and who's not legally on the link. And they take pictures, screen print pictures, the people that is not supposed to be on this link. If you want to join something like this, you have to pay the necessary fees. We can also not have people sending out links illegally, so please be careful with that. So we have people monitoring that. Last week we had a couple of incidents. Please, if you don't belong here, remove yourself and join the next one, make the appropriate booking, and we will be glad to have you with us. We are happy that you're interested. We're happy that you're interested, but we want you to be lawfully interested. All right, guys, we're going to start page 42 of 86. We're going to start in less than a minute on the 2nd. And that's the couple of announcements I want to make. We're not going to go through the house rules again. We usually do it only once. Post your questions there on the chat box. Again, if I'm not answering those people that does have direct access to my chambers, it is because for the next 2 to 3 weeks, I'm so bogged down, I cannot entertain anything. I cannot entertain anything that will take my mind off the instructions on my table. So after that, I'll be available again. All right, guys, almost there. Get that cup of coffee and a ginger cookie or whatever you like so that we can start with contracts again and enjoy it. All right. All right, guys, I'm going to keep talking, saying weird things so that you know you're online, you can hear me, and the people in the office can hear me, and everybody can hear me. I see it's quiet now, so nobody has, at this stage, it seems the sounds as whoever's got a parakeet or a parrot there in the back. What was that? What was that pirate's name with the parrot? What, Captain Hook? In any event, it's gone quiet now, so I suppose that person muted on their side and put a camera off. All right, guys, that's at 12 o'clock on my side. We're going to start. You can go to page 42 of 86. Welcome to contracts, advanced contracts. It's always advised that you attend the basic drafting of contracts course before you arrive here. And that basic drafting contracts course is based on the template introduction course of this course. That means there's a whole a teaching on that template and the court cases and the case precedents that goes into that. And when you get here, you're already prepared for what we're going to teach you here. The first contract we're going to do today is partnership agreements. Most enjoyable contracts. I've done literally hundreds and hundreds of them. They're fairly easy. Here and there, a little bit of a complicated side turn, but partnership agreements is something that we all deal with time to time. And also remember, that partnership agreements is not only natural persons that goes into partnership with each other, but juristic persons can do it, and partners and natural persons and juristic persons can also go in partnerships with each other. So let me just bring that immediately under your attention, that the partnerships, there's trust. There's a lot of things we can do for partnership agreement. And I found in my career that in the corporate world, people look for these kinds of links. They look for these kinds of agreements when they come together. And they're the most easiest one to set up. So let's start. What is it all about? A partnership, also called an unincorporated joint venture. Did you know that? We all know a JV. A JV is a joint venture, but this is another name for a partnership is an unincorporated joint venture. It's the relationship existing between 2 or more persons. Now, they're in persons, you can write for me at the top, they're legal entities who join together to carry out a trade, a business, or a profession. The reason I want you to write the legal entities, I don't want you to forget, it doesn't just have to be natural persons. It can be mixed up, totally. And I myself, before I became an advocate years ago, have been in a few of them where we have gone into partnerships. A partnership is also a separate legal person or taxpayer. Each partner is taxed on his or her share of the partnership profits, and that's how you have to declare it if you do it right. Each person may contribute money, property, labor, or skills, and each expert to share in the profits and losses of the partnership. It's similar to a sole proprietorship, except that a group of owners replaces the sole proprietor. And just be careful with that statement. Remember, sole proprietorship pertains to natural persons, and I've just told you this can be between juristic persons too. So when it's between juristic persons, then obviously you won't make a statement like this in terms of sole proprietorship. I just want to make that clear to you. Take that into regard. As is the case for the sole proprietor, the partnership has its advantages, disadvantages. Please ignore the word sole proprietorship. It will only apply when we refer to partnerships and they're all natural people. When it's something else, then obviously sole proprietorship can never apply. The statement is not wrong, but I just want to qualify it because there might people, or there's even of my senior colleagues out there, because when you get to our level, you question everything in law. We say, hey, we just need to qualify that, and I have qualified that now. Okay, what is the advantage of the partnership and the disadvantage? Let's have a look at it, because this is the kind of things you have to keep in mind when you draft. And of course, remember, you don't just draft a contract, you go into consultation with the clients. And so you have to explain this. And then they will react back to you, and that reaction will guide you in terms of your instructions pertaining to what type of partnership or any agreement for that matter you are going to draft. Easy to establish and operate. I love them. There are no statutory audit requirements. They are great. And then unlimited liability of the partners, of course, liable in your personal capacity. We'll talk a little bit about that later on. And then general greater financial strength. Each party may be held liable for all debts of the business. That's an advantage. This is a disadvantage. Therefore, one part who's not exercising sound judgment could cause the loss of the assets of the partnership, as well as the personal assets of all the partners. And then the last one there on that side, that's very important for me. If the partnership estate is sequestrated, the estate of the partners can follow unless the partners undertake to pay the debts of the partnership. Have a look at that. Have a look at that. The right way to do this is usually, most partnerships, if I put up a partnership, I usually insist on the partners telling, give me a name for a partnership, XYZ partnership. So the right procedure to follow is that the partnerships will get sequestrated. And please remember that in the case of juristic persons, when you go to the juristic persons' individual capacities, then we call there for liquidations if we branch out there. So please take note of that. That's actually how it works. And a lot of people always think they go directly for the partners. Now, you can cite them if you want to. That's totally possible. But that is actually the correct way of doing it. First, you'll go for a partnership, especially if it's a well-established partnership. Please remember that all partnerships are not well-established partnerships. You get quick partnership. Two guys get together, they put up a partnership agreement, they're together for a year or 2 years, they don't necessarily have assets and offices. These are all the things you have to take into consideration also when you want to do a sequestration, or if it's juristic persons, then again, it will be a little bit different. Combines the different skills of all the partners, that's always a good thing. Authority for decision making shared, and differences of opinion could slow the process down. All right, that That could be true that people argue. Each partner has a personal interest in the business. That's very true. And it's not a legal entity as a juristic person. Remember, if it is juristic persons that makes up the partnership, those independent and individual juristic persons still retain their own status as legal entities. All right. Lesser degree of business continuity as the partnership technically dissolves every time a partner joins or leaves the partnership. Please explain this to your clients. Now, I've seen that they don't always understand. They think if a person leaves, that they can just go on with the partnership under the same name, etc., etc. The same goes if a person dies. You cannot do that anymore. As people come and go or somebody is added on, it's a new partnership. And usually what I would do there is I would draft an amendment. That the content of that amendment would be, if somebody comes in, would be to the extent that pertains to the existing agreement, it stays the same, but that specific partnership entity is now a new one. So you're going to have to go and read the case precedents of that. People don't understand it. You need to explain this to your clients and keep it in the back of your mind when you are drafting. There are 3 different types of partnership. The best one, or the most ordinary one, is then the general ordinary partnership. Partners are liable jointly for debts or profits of a partnership. There you go. So they can never escape that. If you're going to attack the partnership first and you can't get everything out of there, you'll go there. And in some instances, you won't attack the partnership first. And you'll go for them directly. Usually you cite all of them. Anonymous sleeping partnerships. The anonymous partner is not known to the public and is liable to the partners for pro rata share. So usually what would happen here, if the front guys were to lose a case and get sued or whatever the situation is, when that is finished, they can turn to the anonymous partner and say, right, now pro rata, you have to deal with us. The commandeitarian partnership, the partner is purely a financial participant with a restricted liability similar to a shareholder in a company. He shares in the profits or losses, but their liability is restricted to the specific contribution or to an agreed amount. So I want you to have a look at that. That's the 3 partnerships you get out. Now, there's something I want to say here. When you look at an anonymous partnership and a commandeitarian partnership, this can create problems. Because there's a reason a person is specifically anonymous, a sleeping partnership. They don't really want to be known. So you're going to have to decide how you're going to contract with it. What I used to do in the past, and it's just advice, you don't have to do it in this matter. When I deal specifically with anonymous, a person say, I'm anonymous, this means I never want anybody to know I am involved here. Especially people coming and says, well, I don't want my wife to know I'm involved in this. Now remember, you need to give due cognizance to what type of marriage they're also in. So that's also important. I used to do back-to-back agreements. Because what happens a lot is when you transact in the corporate world, there's certain instances where people ask you a copy of this agreement. And then you cannot call that person anonymous anymore. So what I used to do is I used to put them a back-to-back contract up. And the first contract will deal with the partnership. It will refer to anonymous partner. It will not mention him. But then I had a back-to-back contract, another contract, where he contracts with them, and they are part and parcel the same. It's tricky. It's difficult. It's not that easy to do it. But that's how I protected the concept of anonymous. You might say to me, but I've got a much easier way. Then, of course, good for you. All right, the content of a partnership agreement. Let's have a quick look at it. This is easy work. Let's quickly recap on last week. The electronic stuff was good. That was enjoyable, but it's difficult to draft credit agreements. Then we dealt with surety session and acknowledgement of debt, and they're fairly easy. But when we throw the concept in there of a reversionary clause, that kind of became a little bit complicated. Again, we're dealing with partnership agreements again. And they are fine. They're not that difficult. Credit agreements specifically within the ambit of the National Credit Act. I mean, if you put a National Credit Act and a Consumer Protection Act beside each other and you read them, you'll see that the National Credit Act is very complicated, very difficult to read. Where the Consumer Protection Act, I was always amazed with this, reads much easier. So yeah, the same with the Companies Act, very complicated. And because of the complicatedness, if I might call it that, of this specific legislations, that overcomplicates a drafting of an agreement within the ambit of those legislations, because obviously you have to interpret what you're reading and you have to build it into the agreements. Partnerships, therefore, easy and enjoyable to draft and takes less time. All right, let's have a look at it. The essentiality of the agreement that the partners will conduct business together as partners with a view of making a profit, and that they will share the profit or the losses. Please put a line there under all the losses so that you can emphasize that. It is important that we bring that under your attention and that you explain it to the people that you are going to join in a partnership. The identity of the partners must be clearly stated. The contributions to be made by the respective partners. Identity is always very important to me. We've lost cases because that was not correct. The manner in which profits, losses will be shared, usually it's percentage-wise. It can be in another way, but usually I always say to the people, let's do it percentage-wise. What do you think percentage-wise is your interest here in terms of profit? And let's keep that the same as losses. Usually it's 50-50, but then of course if you got more people, then that changes, right? And sometimes people are like, well, I've given more money, it's going to be 70-30, whatever the situation might be. There's other ways also of doing it, but I have found that percentages does it the best for me. How the capital of the partnership will be arranged and regulated, the manner in which financial records will be kept, and just right there, this must be done according to legislation. Although you don't have these official audit reports, you're going to have to keep your records, that's law. Especially if you deal with SARS. How the capital of the partnership will be arranged and regulated, that's very important, very important. I can think there of profits and when and what and how. Arrangements in regard to the partnership bank account. A lot of people don't even put up a bank account for a partnership. But if it turns later on to become an enterprise, then by all means, some people say, no, we want it from the beginning to be transparent. Drawings by partner is basically the same as you're going to regulate finances. You cannot just take money like you want to. You get that in partnerships. People do that. And at the end of the day, that always ends up in court, and even criminal court. Management arrangements, very important in partnerships. I usually ask people, who's going to be the financial manager? Who's going to be the operational manager? Who's going to do logistics? How do you see this? So usually that's what I do there. So management arrangements, I take a lot of time to make certain that I put out those duties within the partnership agreement, or I would ask them, go and write your duties down. And then later on, we'll have a consultation on it, because as a legal practitioner, you see more. And I could also then attach it as schedules to the partnership agreement and just refer to this person will be the operations manager as per the duty set out in Schedule A. And so you can do it. There's many ways you can do it, but it's very important because people step on each other's toes. And the one thing about partnerships, people split very easily. And that's what you want to set it up in such a manner to mitigate the risk of that happening. Limitations of partners' authority, very important. Professional indemnity insurance, that will only happen. Well, professional indemnity insurance, you can think of attorney partnerships. There we go. You can think about the LPIIF. So there you go. Most partnerships I have drafted didn't want this. I think one or two I drafted, which were very big. People were paying in like 10 million rand or $2 million US. Then this kind of thing has to happen. They talk about that. And then, of course, the emphasis is on professional, especially think about partnerships incorporated, all those things, attorneys. Arrangement in regard to the goodwill of the partnership. I always build in clauses. You can write there fiduciary. I always look at the fiduciary aspect of partnerships, and I build something around it, and I say something around it. When people read it, I say it in a manner that educates people. What is the obligation towards each other? Termination of the partnership and the rights of partnership on termination, that's very important, because obligations and stuff goes on afterwards too. IP, intellectual property for existence. There's a lot of things that doesn't terminate at a termination of the agreement, and you need to deal with it when you draft. Limitations on liability for partners, inter se, if any. You can deal with that. You can write lesser liability in for some of the partners or more for other partners, or you can do your normal identifications over the board. There's a lot of things you can do there. So you must ask them. You must the whole time ask them when you're drafting these clauses. Then you must ask them. That's why I stand behind the template we are teaching you. Because what you can do in your first consultation, you take this template and you say, right, guys, this is a general template of agreement. This is the most important things in the agreement. Let's talk about this and get some notes on this. That means later on you don't have to bother people so much with questions, etc., etc. Check the terminology is not used, which confuses partnerships with the company law. This is very important. Please have a look there at Hughes versus Riley and others in 2010 that you don't do that. I'll give you an example of this. I always find it interesting, this concept of members directors. You know, strictly speaking, companies has got directors and close corporations got members. And I see people throw this a lot around nowadays in the wrong sense. So make certain when you deal with terminologies, you deal with it right. For instance, in partnerships, you'll deal with partners, stuff like that. And then also, you can deal with abbreviations, but you will deal with that in the interpretation division if you do that, if you're going to break people's names down. Because obviously, in a partnership agreement, when you start to look at duties, obligations, and positions, then you're going to have to refer to specific people. So just deal with it right. Deal with it right and make certain. And read that court case. It's 2010, and you know how I deal with that. If it's after 1996, I'm kind of happy with that. 2010 is already a strong year deep into the Constitution with a lot of constitutional rulings coming out. Not that that is per se constitutional, don't misunderstand me, but after 1996, I'm more comfortable with those rulings. Drafting of a partnership agreement, we have attached above on it. Okay, so okay, let's have a look at it. Heading of the contract title. Now, with partnerships, make a note there. You can really become creative with a partnership agreement. You can really call it what it is. So-and-so partnership agreement, engineering partnership agreement, or whatever. I know that people want to put their names on things. I always say to people, as far as possible, keep that out of the heading. Pick a name that refers to what you're doing. So when people see your name, they kind of know what this is all about. So I try to influence people in that manner, but every now and again, people will say, I'm sorry, this is Maslangu and Naidu, and that's the way we want it, and that's the way you run with it. Then, of course, subheadings in contracts, sometimes, especially under the National Credit Act, I can see that is very important. You can do that a lot. The citations of the parties to the contract, please, I'm going to reiterate. This is imperative, guys. You really have to look at this to do it 100% correct. And that's why the basic draft of contract calls, even if you want to fall back now, maybe you haven't done it, you can still go and do it. And it's important to do that because that's where we teach you under case precedent, under law, how to do it. And you will be amazed with how I cite juristic persons. Only the people now listening to me that was on a basic drafting course will know how tough I am on the citation of juristic persons. And in my citations, where I built in various documentation as annexures, in my citation, for example, resolutions, wind deed printout of companies, you have no idea. All right, agreement to the contract in the whole, you always have to start with that bold, the following people agree as follows. And then you have an index again. You won't use an index if it's a short partnership agreement. There's your preamble. Look at that. Conduct of business partners, share profit and loss, and stuff like that. You might want to talk about that. Usually on the preamble for partnerships, I would say what type of partnership is going to be, what it's going to be all about. And then I'll talk a little bit just in a short paragraph about the history, and the third paragraph about the partners being desires to partake in a specific type of partner. Is it a general partnership, anonymous, or commanditarian? You can also call it a commanditee. That's the Latin for it. So then conduct of business partners and share of profit and loss, I would very rarely put on the preamble. I'll rather bring it under specific terms. But that's up to you guys. We all have your own way of doing it. There's your interpretation. I want to make a statement here. I don't think in a day and age we're living in, you can go without interpretation, where you give certain terminologies definition. For example, I just said ex-commanditee, ex-commanditee. That's a commandatarian partnership where it gives a certain amount of money, and then you can explain it there. I'm thinking about a word like estoppel. I'm thinking about Latin words. I'm thinking about English terms that's difficult to comprehend for the lay person on street. So you can use that interpretation, open interpretation until you're finished. It's always a good thing to have. Specific partnership terms of contract, contributions, there you go. Manner of profits and loss sharing, there you go. That's also where I built it in. Partnership capital arranged and regulated, financial records, partnership bank account, drawings by partnership. That's a big fight. That's a big fight. Yeah, that's a big fight. So please, guys, partnership drawings, you got to be strict on that. You got to say how that's going to happen. Management is imperative. Management is imperative. Are they going to be equal? One is going to be the operational manager, one a financial manager, but they will talk to each other about decisions. Is there 3-4 people? Is somebody going to be the managing partner, whatever you want to call him? So management is very important so that people don't muck around in each other's authority. There is your limitations on partnerships authorities, professional indemnity insurance, again, depending on how it's going. Goodwill, you can write again, your fiduciary aspects. Termination is always important to have a look at that, and limitation on partnership. Liabilities, you can decide what you want to do. I usually go general on it. I use the general clauses there to cover with it, except if somebody says, no, we want it to be like this. Another thing about agreements, again, partnership agreements, also make certain that you don't have to go into consultation only with the attorney. That's going to get you nowhere. Go into consultation with the attorney and his clients. And if you're going to put up an agreement and you're going to have all the parties, not both, all the parties there, that is the way to go. Yeah, I know, it's not always possible. Sometimes you only got to see this attorney's client, and then they've got an attorney on the other side, he's a client, and then you start paying a lot for the drafting of a contract because the one attorney reads something and he says, no, that's not correct. And you start going into those directions. Legislative clauses, deal there with SARS. Deal with SARS. And if you are binding juristic persons in partnerships, make certain that you deal with everything you need to deal with there. For the first thing I can think of you're going to deal with there is resolutions. So make certain you have the law there, make certain you read everything and you do everything 100% correct. Common terms, there you go. I don't need to go through them again. I will, but that is your boilerplates. That is your operational requirements, whole agreement. Yeah, variation by all means. Relaxation of terms, yes, there's your jurisdiction. Doesn't have to be magistrates court, but it's always a good idea to start lower than higher. I was in court one day when a judge in the High Supreme Court chased a case out of there back to the MAC court. Now, I don't agree with there because there is a constitutional court case that says that if there's concurrent jurisdiction, I've got the right to pick where that case has to go. It was a good judge. I liked him a lot, but they just got fed up because they got bogged down with small cases. Couldn't get to the bigger things. Address for service. All my learned colleagues would know that's your domicile executandi. There's your legal costs again for drafting of the contract. I told you last week, draft it in there. If you can, draft the fee in there and draft who has to pay for it, whatever the situation might be, and draft there when they have to pay for it. Listen to me, guys. There is in my younger days contracts I've not been paid for. I just walked away. I never worked with those people again because these things were not addressed. Legal cost for litigation. Have a look at that, and you can pick there what type of legal costs the losing party will pay. Just make certain that it's legal. Some you cannot write into certain contracts, and people don't know that. And then further commentary, maybe there's other costs involved that other legal costs you can think of. I can actually not think of other legal costs now at this moment, but I'm sure there could be something else there. Alternative dispute resolution, decide what you want to know, do there. Always remember that arbitration, the third one there, is very expensive. Negotiation, mediation is all right. And in any event, you can write there if you want to. Rule 49, capital A of the Uniform Rules of Court. In any litigation, criminal and civil, you're going to engage now, you are going to have to deal with mediation. The whole country is going into that direction of stop the fights, let's see if we can talk it out. So we're moving in that direction. And that's indigenous concept. That's indigenous concept. We Europeans more like, let's attack each other, kill us. But the indigenous concept is more, hey, sit down, let's talk about this. See if we can. So we're going kind of back to that, but on the legalistic foundations, well monitored. So you're going to decide if you want all three of them. And remember what I said last week about arbitration and breach. They can both be in the same contract, but then you must relate them to each other. You cannot have them independently there because then how do we know which one to pick? Do you understand what I'm saying? So there you are. There's the breach, governing law, joint and severability. I dealt with that last week. Confidentiality, you write in brackets beside it, POPIA. That is your Personal Information Protection Act. So I want you to write it there. This is becoming paramount. I cannot see contracts anymore that I would draft where I would not say something about it. All right? So that's kind of important to me. Counterparts, that's for signing. Execution of contract, where, how, what, all of those things. and all of those things are important. There's your annexures. Annexures division is very important for me. For example, I cannot think where I don't want to have annexures, because if I cite natural persons, I attach copies of their identity documents. You have no idea how I approach this. I'm very strict. I'm in detail. It takes a while if you come to me. A lot of attorney firms, what I do every 1 or 2 years, they send me 5, 7 types of contracts. They say, draft me templates. Draft us templates we can use for the next 2 years. And then every year or two, they come back and I have to amend them. So you set templates up for attorneys firms. And when somebody walks in, they've got a template. They can work from it. And then, of course, you just have to keep updating. Where do you update templates? Yeah, sure, with the amendment of legislation. But one of my biggest sources under these instructions I have from firms is on case precedent. We go and read for especially eviction, voetstoots clauses. There's so excellent appeal court cases on that. And that's how I then every year they send it back, and then I would just update them and in terms of what's happening within your court system. Right, date and location pertaining to the signing of the contract. Come on, guys. I've looked at big businessmen and in a boardroom and just shook my head. I can understand it. Signatures, people walk in there with agreements that's not signed. I had it a couple of times, and I told you last week why I think it's imperative that page numbering of the agreement agrees, and make a note there, running right through to the last annexure. I won a case like that, one in my whole career, where they said that document is not part and parcel of that agreement. And I told you last week, I was sitting there in my chambers and it wasn't going anywhere. And I was paging, and out of the blue, I saw, wait a minute, this is the same print style, blob style, what these machines do when they get old. And when we brought it under the attention of the opposition, that wasn't the defense anymore, right? So page numbering of the agreement, let it run right through. That is what because that makes that part and parcel of that agreement. So that's the things I want to bring on your attention there. Let me just page. Okay, let me just page. Give me a second. See, I've made other notes here when I prepared to do this with you guys. No, it's cool. It's cool. We're good. That's partnerships agreements then for you, and that's fun. To draft a partnership agreement is fun, and to see how entrepreneurs comes together. The weirdest partnership agreements imaginable. And I still remember one day, well, for 3 months I've been working on this thing, and we met in the Wimpy in Irene. And 6 or 7 guys came, and we had a nice meal. I still had my laptop there, and then they still wanted, after 3 months, more amendments. So I paid a Wimpy $100. They printed it from my laptop. And I think I told you on another group this, that late at night or early that morning, waiting for the aircraft, they got into a fight that very same day. And I had to get up. A draft termination agreement for them, which they printed somewhere and signed. Got into a horrible fight. These things happen. All right, now pre-incorporation agreements. All right, pre-incorporation agreements. Guys, I don't think this is too complicated. There is a snack or two here. But let me explain before we start reading. What is a pre-incorporation agreement? Well, it is an agreement dealing with an entity that's not yet been incorporated. That's as easy as it. Everybody always have a fright when I hear about a PIA. It's very easy. It means I'm going to set up an agreement before this corporation or this entity is incorporated, meaning registered with the CIPC, something like that. That's a pre-incorporation agreement where a couple of guys, we got together, we say, hey, we're going to open a PTY limit or a limited or whatever, a ring fence company, whatever the situation might be. We're going to open it up, but we already have stuff. We must first agree amongst ourselves how it's going to work, but we're already going to start doing stuff. We know opening the company is going to take a while, but we need to get going now. And then you start engaging in pre-incorporation agreements. Now, there's only one thing before I start reading on pre-incorporation agreements I want to bring under your attention, and that is the concept of liability. All right, you have it. There's the common law and there's the Companies Act, the concept of liability. So that is something that we need to go and look at. All right, are you ready? This could be a bumpy ride, so buckle up and let's see where we end with this. I've done a couple in my years as an advocate. And one thing about these things is you got to sit and you got to apply your mind to legislation. First of all, there's common law also involved. You'll see it shortly. But you've got to make certain that you do this 100% correct in terms of the new act, specifically Section 21. When you draft this, you got to be careful in terms of liabilities. All right. A pre-incorporation contract is a contract that's entered into by a person who's acting on behalf of a company that does not exist. There you have it. Does not exist. The person entering into the agreement has the intention that once the company comes into existence, the company is to be bound by the provision of the pre-incorporation contract. Now, on the one side, you have liability. On the other side, you've got this tense situation of bound. Is to be bound. That's where the problem is going to come in. So let's see what the new act, we'll be talking about an old act too. We'll see what a new act is saying. There's Section 21. And before I go on, I wanted to say something. You might have heard it in my voice, and then I forgot. Pre-incorporation agreements, I always approach educational too. People walk into your office, they say, we're going to put up a company, but stuff is not happening now. Let's set something up. And they would say, well, that's a PIA. That's a pre-incorporation agreement. And I say, what the heck is that? All right. So I also draft educational, specifically pertaining to liability, and this being ratified, or whatever the situation is, in terms of being bound after the company is registered. They don't always understand. It can be tricky. It provides that a person may enter the written pre-incorporated contract. The board of the company may ratify or reject the whole agreement, part of it, or on certain conditions. Dangerous, right there. Dangerous situation. You got to make certain when you draft this, that the people that's liable don't incur damages after the company has been brought in and it's now registered with CIPC, and maybe there's 2 or 3 directors and they don't like what's been done. That's just one example I'm giving you now. So many things can go wrong, and that person is stuck with the liability that he signed under the pre-incorporation agreement. You must endeavor when you draft the first one there, you want to ratify the whole agreement. Now, do you see company may ratify or reject? You don't want to get close to reject. You want the whole agreement. You don't want parts of it or in certain conditions. You gotta know what you're doing when you're drafting a pre-incorporation agreement. Otherwise, somebody's going to be mad at you. This must take place within 3 months after incorporation. If ratified or deemed to be enforceable against the company, it operates retrospectively, as that means backwards, retrospectively back since the date was signed. And the liability of the promoter is discharged. Who is the promoters? The guys that set it up, that was party there, that took the liability. If any part of the contract is rejected or the company is not incorporated, the promoter and other such person, don't worry about other such person, can be anybody. Can be the guys that's doing this with you. Can be anybody. I don't want you to pay too much attention to what I did there in the act. Are jointly and severally liable for a contract, Section 21 sub 2, but if the company benefits, a promoter that is held liable may claim a refund from the company, and that's not just the common law litigation. That is Section 21 sub 7, and that's why you need to be educational, and you can draft all of these things in. So actually what happens is 3 months, if you have a pre-incorporation agreement, 3 months after that company has been registered and nobody does anything, then that agreement is automatically ratified, and that will be on the whole agreement. That's actually what you want. You don't want to muck around with this, because some of these people, they become liable for millions of rands. The reference to other such persons seems to be a reference to the other directors or other parties involved in a pre-incorporation transaction. Don't pay too much attention to it. That I agree with, because you're sure as heck not going to sign a pre-incorporation agreement with yourself, are you? So other persons, I don't know why they went in that direction, or they set it out like that. Don't pay too much attention to that. Section 21 does not exclude common law alternatives. Aha, you better underline this. Such as a contract for the benefit of a third party, or a trust, or a cession and delegation. The construction is determined by the wording. The wording is therefore important, as the promoter is not automatically liable in terms of the common law as he is in terms of Sections 21 of the Act. So please mark this, SMB, if you're going to go into this direction. And for any agreement, you know, we've said last week in the 2 sessions to think what you are saying. That's why you need a basic drafting of contracts course, because we literally show you words that you shouldn't use. I don't always agree with those, but we show you how to draft, and we pay special attention to the wording, the words you are using. And you can imagine if I now suddenly drafting in terms of a third party to a trust, a cession, delegation, then suddenly this pre-incorporation wording is going to go in a different direction. So please have a look at that. The New Companies Act 2008 states simply and briefly in Section 21 sub 1 that a person may enter into a written agreement, please underline it, pre-incorporation agreement must be in writing, in the name of or on behalf of an entity that's contemplated to be incorporated in terms of tax but does not yet exist at the time. And there it starts off the Section 21 there. That's what that's all about. The only formalities for a valid pre-incorporation contract under the New Companies Act are thus that a contract must be in writing and must be entered into the name or in behalf of the company still be formed. So make a note there, they're going to have to pick a name. Have to pick a name. So how do you pick a name? What do you do before you open a company? Make a note there. You make a name reservation with CIPC. You give them 3 possibilities. They come back and people can decide. I actually want to advise that never get into a pre-incorporation agreement if you don't have a name. Now, a lot of you would differ because a lot of you, senior colleagues especially, colleagues at my level, has already drafted this documentation, has done it without a name. But it's just my advice that for identification purposes, I would rather that they do that reservation, or if they don't do a reservation, name reservation, that they at least pick a name and decide later to change it if the name reservation comes back negative. The new act has thus dropped the pointless bureaucratic requirement of the old act that a memorandum of the company when its form must state that one of the company's object is to ratify the contract, and has also dropped the requirement that a pre-incorporation contract must be lodged at the Office of Register of Companies together with the company's memorandum and articles, which is now referred to as the Memorandum of Incorporation. No, no, no. Guys, listen to me. I'm advising you that it's not a requirement of the law anymore, but I still want you to do this. If you put up your MOI, especially if you don't use the standard one, you draft your own one. Over COVID, I had a client, a very intelligent client, also who became an attorney just now, a very influential guy from Canada that drafted his own MOI, and it was brilliant. It was out of this world. I am advising to you, although these are now being excluded from the Act, please draft in your pre-incorporation agreement in that MOI. Make reference to it somewhere, because you do that also with a shareholders agreement, and when you do that, it becomes part and parcel of that. And the reason I'm doing it, I'm going for totally being official in terms of what? Liability, 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 and protecting those guys from the very beginning. So you don't have to do it anymore. Nothing says you shouldn't talk about it in your MOI. Section 21 sub 4 and 5 of the New Companies Act makes crystal clear how much time the law allows for the Inversar company to ratify the pre-incorporation contract made on its behalf. We know now it's 3 months, and lays down a default rule to cover the eventuality that a company neither ratifies nor rejects a contract. And we know, we said it, I'm not going to say it again there, I'm going to just browse over it. We have said there that then it automatically is accepted, etc., etc. You know what, let me rather read it, because I think they talk about, but let's have a look at here, something I'm thinking of now. Within 3 months after the date in which a company was incorporated, the Board of Company may completely pass your condition, ratify, reject the incorporation contract, or other action purport to have made. That doesn't, okay, we had it. If within 3 months after the date in which a company was incorporated, the board does neither ratify nor is a part of the contract, or other action purport to have been made or done in the name of the company or on its behalf, the company will be glad to have, okay. All right, good, that's what we said. I thought I was thinking of something else, but it didn't show there, so I'm not going to worry about it. Let me just take a sip of water here. We will break on the hour for about 8 minutes. So you can run somewhere. Although it's actually, I suppose, more for me to have a break than you, because you can walk away from your laptop and come back. Am I right? The New Companies Act does not state in Section 21 sub 3 and the Section 21 sub 6 and sub B that if the company after it comes into existence ratifies the pre-incorporation contract made on its behalf, or if the company enters into another agreement either on the same terms or in substitution for a pre-incorporation agreement, are you with me? Then the individual who represented the company is thereby released from all legal liability, even if the company thereafter is unwilling to carry out its obligations under the contract. Make a note of this. Make certain that in your consultations you bring this under the attention of parties and say, this is where the buck stops. The liability is gone for those pre-incorporated guys. If this happens, or if you amend the contract, whatever the situation is after this company has been registered, then of course Even if the company cannot perform, there's no fallback on the pre-incorporators, the promoters. All right, you happy with that, guys? Interesting stuff, eh? For a pre-incorporation drafting agreement, that's very interesting stuff, eh? And that's why I say this I approach educational, because the man on the street does not know this. However, as can be imagined, the other party to the pre-incorporation contract may feel justifiable aggrieved at being led down the garden path if he or she finds that a company, when it comes into existence, rejects the pre-incorporation contract or part of the contract. Now, this is the crux of the problem, isn't it? And this is why you have to be very careful in terms of signing that, because the promoters, when signing the pre-incorporation agreement, must sign it to such a foundation that this does not happen. The right wording, the right intent, even if there's new directors coming in, that they cannot change this and bring this liability back. And this is where the problem comes in. If this is not done right, this will bite you literally in the ass. All right, that's putting it in the right perspective, I presume. The New Companies Act deals with the situation explicitly by providing in Section 21 sub 2 that anyone who enters into a contract on behalf of a company not yet formed is jointly and severally liable with any other such person for liabilities created as provided for in a pre-incorporation contract, while also acting if the contemplated entity is not subsequently incorporated. Now that's if the company is not registered at all. You understand what's happening here, guys? That means if that thing is never, that entity is never registered with CIPC, logically, if there is obligations that has to be met, I don't know, they bought something on credit that a company was going to need, they're going to have to fulfill those obligations. Or after being incorporated, the company rejects any part of such an agreement or action, and that's where the big fight comes in. So please, guys, take note of these things. Everybody I've seen in chambers when I draft contract, everybody's, no, I've got a pre-incorporation contract to draft, it's quick, no problem. That is the biggest bullshit under the sun in terms of any agreement in the modern world we are living in, as a matter of fact. The New Companies Act thus ambiguously imposes personal liability on the individual into the pre-incorporation contract on the company's behalf if the company thereafter rejects the contract in whole or in part. And can you imagine that fight? All right. I just want to say something here as a litigator, a civil litigator. I'm thinking about something, guys. Make a note there, this paragraph, that remember, if the agreement is rejected on the foundation of unreasonableness, maliciousness, all of those things, you can go and fight it in court. Make a note there. This is not a dead cow. You can go and fight it in court. What I'm reading here doesn't say, hey, if they say no, it's no. If they've been unreasonable or acting unlawful or being malicious or whatever the situation can be, you can take it to court. Our courts are becoming more liberal every day, and they will entertain you if something like that's happened, I can assure you. I've had some weird rulings. Thought I'm going to lose a case, and then suddenly the ruling comes out, you didn't lose it, and the verdict is very liberal. So please, contracting out of liability in the eventuality that a company does not ratify the pre-incorporation contract. Now that's clever. That's clever. Can we do that? Can we do that? Let's have a look at what we've got to do here. Entering into a pre-incorporation contract in behalf of a company as yet unformed is not a step to be taken lightly because of the personal liability that will be incurred by those who profess to act on behalf of the company if the company rejects the contract. So there you have it. In this regard, it's not possible for a pre-incorporation contract to state that a personal liability provision section 21(2) of the company in regard to pre-incorporation contract will not apply. This is because these provisions of the Act are not expressed as being alterable provisions. Right there, now I'll tell you now. Let me just finish here. That is to say, they are not provisions that the Act allows the parties to alter by mutual agreement. Now, in my and your law, what is that? What is that in my and your law? It means you cannot, that's right, you've got it, you cannot contract out of the Act. In terms of section 21(2), you cannot contract out of the Act, right in there. The National Credit Act is the same. Consumer Protection Act is the same. There's certain things you cannot contract out. The law says you cannot do it. It will be in there. So that's important to look at that. Né? However, the language in section 21(2), in particular words as provided for in a pre-incorporation contract, is such to allow the pre-incorporation contract itself to be expressed in such a way as to make clear that no personal legal liability will attach to the company's representative in the eventuality that a company is not formed or is formed and then rejects the contract. Now, you have to underline the word representative there. All right. So there's another twitch there under the common law that's very interesting, and they talk about that in the wording. The wording of the Companies Act actually allows for that to be done. So let's go look at a court case to see what this is all about. Personal liability in terms of Section 21, can it be avoided? Section 21 of the Act provides that individuals concluding a PIA may enter into a written agreement in the name of or purport to act in the name of or on behalf of a contemplated company. According to Venelix Pty Limited versus Vigraha Property CZ, if the PIA is concluded in terms of the Act, the individuals will be acting as an agent of the company not yet incorporated. Okay, all right, we get that. Such individuals will in turn become jointly and severally liable if the contemplated company is not subsequently incorporated or fails to fully ratify the PIA post-incorporation. Big words there. In other words, all agents will be liable for any loss suffered by third parties because of the company's repudiation. This is an unaltered provision of the Act meant to protect the third party to the PIA and means that agents cannot avoid such liability using Section 21 PIAs. But what about, is it possible? What about that? The only way to escape such liability is to structure the written PIA in terms of the common law principle, and there it is, stipulatio ulterior, or contract as a principal, not an agent, for the benefit of a third party. This form, unlike the statutory Section 121 version, does not provide a third party with disproportionate protection against the parties acting for the benefit of the contemplated company. In terms of stipulatio, there are no harsh consequences of personal liability for the parties acting for the benefit of the company that is yet to be incorporated. If the contemplated company is not incorporated or that rejects the PI upon incorporation, the contract simply falls away unless otherwise provided in the written PI. And I want to caution you guys to be careful to draft it. This is thus the difference between acting as a representative in a form as an agent and acting as a principal. And when you act as a principal, then you can rely on this. Be very careful with this when you draft this. Not that, let me explain where the concern comes in when you draft this. You might not know how to use the terminologies here, which means at the end of the day, you're going to go for principal, but you end up with agency. At the end of the day, go for agency, you end up with principal because you are not well versed and well experienced in this. Please be very careful of this and go and read all the lawful resources, law resources and case precedents that can show you totally how to do this. This is not a joke. You have to ensure you're using the appropriate type of PIA. Structuring the agreement to clearly reflect the intention of the parties as to the type of PIA can become done in various ways. In the Venelix case, the court's analysis concluded that individuals acting on behalf of the company were not acting as agents in terms of Section 21 of the Act, but that they contract as principals for the benefit of the company that is to be incorporated in terms of the common law. You have to go and read this court case. You don't have a choice. If you're going to do this on the foundation of a principle, you have to. Please make a note there. Pull that court case and read the court case. Otherwise, you've got to ask me. You've got to ask me to send you the court case, and I will send you the whole court case. Yep, I can hear the fingers typing now at a terrible speed. In terms of the common law stipulation, we'll tell you now what stipulatio ulterior means in total, if you still don't know. A newly incorporated company will have an election of whether to accept the PIA or to reject it. If the company accepts the PIA, then obligations to such contract will only arise from the day of such acceptance, not when the principals concluded the contract for the benefit of the contemplated company. If the company is not incorporated or he rejects the contract upon incorporation, the principals acting for the benefit of the contemplated company are not held personally liable. And that's the thing you want to get away from. Isn't that true? You want to get away from that personal liability, unless otherwise stated by the PI specifically, and the contract will simply fall away. Now, I need to just say, do you understand what it's saying? If you do the principal situation, you can still have them personally liable if you draft it into the agreement. Don't think these are two different things where you can do now one thing, not the other thing with the agency, and this thing, not the other thing coming back from the personal liability. You can still build it in, but keep it as principal. Lastly, the common law does not indicate a strict time period for election, in contrast to the statutory, so you don't have to 3 months. Make a note there, electronic note, or I don't know if you've printed there, what you're doing, make a note there, the 3 months is out under the common law. In that, election simply needs to be made within a reasonable time, without sanctions if not made. That reasonable time, underline it. The stipulated PI can never be deemed accepted without the newly incorporated company's knowledge if it fails to make an election in a reasonable time. And now I'm drawing back. Now I'm drawing back to the heading of your pre-agreement. Do you remember? So in your heading, decide if we have a stipulated PI or not. So influence your heading in the sense of consensus. Guys, do you know how many court cases there are on the heading of contracts in terms of consensus? And that's why you need to attend the basic drafting course, because we show you there what that's all about. And that's why I'm so strict on the heading. I don't mind using 4 lines to put in a heading. Stipulatio ulterior, meaning a contract for the benefit of a third party, thus valid third party contracts. Third parties may become involved in a contractual relationship between others, such as stipulatio ulterior, for the benefit of a third party beneficiary. The third party beneficiary may claim the benefit only once they've accepted it and may sue for performance. You might like to underline may sue for performance. Right. So let's draft a little bit. In drafting such contracts, we're going to break in 9 minutes, except if I think we're going to just finish up here before we start the last contract. But we're now on 12:51, and so hang in there. We're almost there for a break. In drafting such contracts, you must make sure the contract spells out clearly the intention, namely, whether the third party accepts the benefit or actually becomes a party to the contract. You have to have these things in there. When a third party is entitled to accept the benefit, how the third party is entitled to accept the benefit, whether a person stipulating for a benefit in favor of the third party can withdraw the stipulation before acceptance. Please, guys, when you draft, you've got to build clauses around these things. Pre-incorporation agreements or pre-incorporation contracts establish the operations, management. Okay, we're drafting now. You got to think now. What are you going to say in your contract? We're drafting now. So as I'm reading in your mind, draft clauses in your mind. Deals with operations, management, and define who will have control prior to initial corporate meeting. In addition to the pre-incorporation agreement, many business owners draft a shareholders agreement and a confidentiality agreement. And don't worry, we're going to deal with those. This group of documents can help assure that there are no surprises. Please underline surprises once the corporation is actually set up, because that's what it's all about. Because the corporation is not set up yet, the pre-corporation will give authority to its incorporators, and you can put in brackets there, promoters, but it's not to say that a promoter of the pre-incorporation agreement will always be a principal. We know it can be an agent, can be a principal, so just be careful with that approach and the terminologies I'm using. A good pre-corporation agreement will define the various responsibilities of each of the incorporators. Are they going to be directors? Are they going to be members? Well, yeah, they can still be members, because you can still buy a shelf among companies. So before you buy a shelf company, I suppose then you could put up a pre-incorporation agreement to that effect. What are we going to do? But it's not like you're going to register it at CIPC, because you can't have new ones anymore. The organizers of the corporation who wish to avoid personal liability must ensure that a pre-incorporation agreement emphasizes that a contract party is completely aware that it is associating itself with a soon-to-be-formed corporation. Such an explicit acknowledgement in the agreement can save the organizers a lot of money and misunderstanding and avoid personal liability. There you go. Mark it. These things are so important. It's actually nothing you shouldn't mark. Let me just draft here my book. All right. So to mitigate some of the aforementioned risks, the following aspects should be addressed in the clause dealing with the incorporation of the company. There must be an undertaking given by the agent acting on behalf of the company to be formed to the company will be incorporated within a specific time frame. Now, what I usually do, underline specific time frame there. A specific time frame, again, can bite you in the ass. So what I usually do there is I would put in a specific time frame, but I would put a second subject to, the parties agreeing for another extension, and I would link the another extension again to a specific time frame. Are you feeling me, guys? Are you with me? I will not lock it down, because this is South Africa. And we know within government institutions, how things can get messed up and things are not happening. So you're going to think beyond the borders of just law here. Specific time frame, I'll just build in subject to another specific time frame on consensus of everybody. But again, a specific time frame. I won't keep it open. And on the time, because a pre-incorporation agreement can have real liabilities attached to it, obligations. So you don't want to keep it open for forever. And undertaking that a company will be bound by the contract once incorporated, you got to deal with this. This is just a sentence. You got to deal with this. Go research all the clauses you can find on this and make certain you built in what your clients want there. In the event that a company is incorporated but refuses to adopt and ratify the agreement or rejects it conditionally, partially, or who's to be held liable? Do you see that? Who will be liable as purchaser if any of above conditions are not fulfilled? And that's only where and if applicable. All right. Okay, guys, good. Hopefully you know more about pre-incorporation agreements, and it's fun. It's exciting. It's exciting to dive into the law, dive into the common law, and you know, the legislation and draft something like this and help people build dreams, because people coming together for goals. They make companies, entrepreneurs. You are helping people to get somewhere, and they need your help to get there. That's why you have to do it to the best of your ability. So quickly, let's quickly sum up. How do we draft it? There's your heading of the contract, title. I have a subheading here, definitely, because I want to know what I'm doing as a principal, as an agency, what's going on. The parties to the contract, very strict on that. Agreement to the contract in whole, index. And these agreements, usually there will be an index. They're going to be long. I mean, in a pre-agreement contract, don't make a mistake. You can talk about shareholding too if you want to. There's nothing you cannot do. You can actually talk about everything you want to. And you can make this pre-incorporation part and parcel of the MOI if you want to. I actually say go for it. The preamble to be the name of the corporation, I agree with that. Location for where the corporation will be run from, no problem. Business of the corporation or the purpose of the corporation, absolutely. Clear confirmation by all parties being aware of the pre-incorporation status of the agreement. Oh yeah, I might take that out of the preamble and I would make that something specific, because that is so, the awareness clause is, make a note there, it's imperative. Specifically identified liability if this pre-incorporation agreement is not for any kind of reason adopted by the company when formed in any whichever manner, and I will never in my life put that under the preamble. That's going under specific terms. All right, so that's just the way it is. Interpretation is going to be very important. Specific terms of a contract, full details of all the shareholders. There you go. Quantity and types of shares to be issued. Please make a note there. We don't get any par value shares under the Companies Act anymore. Please make a note there. No par value shares under the new Companies Act anymore. List of initial directors and officers to be appointed to the corporation. Great. Voting rights, corporation financing, management and operations with pre-incorporated authorities for each incorporated, as well for each post-incorporated director and legislative officers. All relevant pre-incorporated liabilities like your stipulatio ulterior. Incorporation will occur in specific time frame. Binding status of the pre-incorporation agreement on a company to be formed. Legislative clauses, alternative legal adherences, agreements must be in writing. Guys, you have to talk about Section 21. I would never draft it without talking about Section 21 on an educational foundation with the promoters. And there's your common terms again, whole agreement, yep, variation, yep, jurisdiction, domicile executandi, legal cost, there that is, there is your ADRs, there's your breach, always with breach. That's why in the basic contract we teach you. There's a very good clause there we teach you for a breach. Breach clause must be a good clause. Please don't muck around with a breach clause. We have some good breach clauses, but you need to attend that course. Governing law, joint and severability, confidential and non-disclosure by all means. Oh boy. Guys, confidential and non-disclosure marked it. And pre-incorporation agreements, this is imperative. Execution of contract counterparts. There's your annexes. You can put this up and you can do a shareholders agreement and annex it to this. And you can annex all of this to your MOI. Make it part and parcel of your MOI. Regardless of the fact that a new act says this, you don't have to PIA, you have to put it in an MOI. I'll still do it. There's your dating location pertaining to the signing of the contract. Signatures, and remember those page numbering of the agreement. Who knows? Maybe you're the next guy that is going to need it. Guys, we'll be back 8 minutes past 1 and we'll start with sale agreements. I'll see you then. I'm just going to push the buttons here that I need to push to get out of here. I'll see you in 8 minutes. All right, guys, we are back. We're going to start in 5 seconds. 8 minutes past 1, 13:08. There we are. All right. Let's take it home. In this last hour, we talk about sale agreements. Now, before we start talking about sale agreements, I don't think people take sale agreements too seriously, and that's a mistake. People draft sale agreements, and everybody think they can draft a sale agreement, etc., etc. One of the things about sale agreements that you have to understand before we start reading here is that the Consumer Protection Act is very important in terms of sale agreements. And then, of course, the fact that aspects like footstress clauses, etc., has to be contemplated. Footstress clauses does not always fall under the Consumer Protection Act. We're going to be looking at all of that. But sale agreements, everybody thinks it's easy. It's not that easy. But what is more interesting is that sale agreements become much more difficult also when we deal with the sale of immovable properties. So we're going to sit back for the next hour with a lot of patience and listen to what we have to say. I have to tell you myself about sale agreements, because the most important aspect we're going to merge into is when you sell a house, stuff like that. And then it becomes complicated, and you will actually be surprised at what I'm going to show you, because although I'm an advocate in civil litigation, criminal litigation, as well as many other things, I'm not a conveyancer, but I've done many cases on these agreements, breach of contract, things like that. And I'm always surprised at how bad some of those immovable sale agreements, the offer of purchase, am I correct, guys? The offer of purchase, that's what we call it, né? That people really muck it up, and it's unbelievable what they do with it, and they never even consult the different laws they have to take into consideration. Alienation of Land Act, for example, stuff like that, Rental Housing Act. I have properties, I sell properties. I'm actually selling all my properties now, and so I know about these things. I know what has to go in there. Apart from the act that for years I drafted them myself and litigated them for especially estate agencies. So sale agreements, you might think, oh, all right, sale agreements, don't do that. Don't do that. Sit back and take this serious and see where we're going with this. There's a thing out there, but sale agreement, anybody can do that. Yeah. All right, let's see if we still agree with that theory when we are finished here. First of all, the definition. I said last week that the definition of any agreement pertains to the requirements of that agreement that has to be met under your specific terms clauses. You have to meet all the requirements of a definition of an agreement to have a legal agreement. Otherwise, people can attack that agreement or say it's invalid or unlawful or whatever the situation is. An agreement of sale constitutes the terms and conditions of sale of property by the seller to the buyer. Seller and buyer, and I think that's why people think, it's nothing, it's a seller and a buyer, that's easy. These terms and conditions include the amount at which it is to be sold and the future date of full payment. Being an important document in the sale transaction, enables the process of sale to go through without hurdles. All the terms and conditions included in the agreement of sale must be understood thoroughly by both the parties and obeyed throughout the sale process till the time the sale deed is made. Agreement of sale is the base document in which the sale deed is drafted. All right. So far it's good. The South African law of sale is an area of the legal system in that country that describes rules applicable to that country, as though we're sitting in Canada saying this. Let me just make something that I want to change that 10.2. I want to take that with in the next guide. Not that I'm going to be doing this. There'll be another guy doing contracts in the future, but the word that has to go. I'm going to have to change that and send it through to Q&A. The South African law of sale is, and have you seen what I just did, guys? Did you see what I just did? I saw a word that doesn't make sense on the foundation of how we're doing this, right? Did you see that? And I'm taking it out. This is how you should be with drafting. Anything that is dubious or creates confusion. The South African law says an area of legal system in that country. I'm sitting in the freaking country. So the word that doesn't fit in there. This is what drafting is all about. Eh? Yeah, sure. So I got to change it. It's my own mistake. I got to fix it. That's my mistake. I take full responsibility for it. I got to fix that. Country that describes the rules applicable to a contract of sale, or to be more specific, purchase and sale, or MTO venditio. Generally described as a contract whereby one person agrees to deliver to another the free possession of a thing in turn for a price in money. And that's actually the best way of looking at it. The MTO venditio. You can look into your girl's eyes and say to her, MTO venditio, hopefully she says you are in love with her. She's going to think you are very clever. The Consumer Protection Act, very important with sale agreements. We cannot get away from it anymore. I said in the beginning, I explained to you that even if you buy a vehicle on credit, that the vehicle is under Consumer Protection Act. But I also said last week to you that the service they are rendering to you and giving you that loan, that is a service, because the Consumer Protection Act is all about what? What is it about, guys? Services and goods. Services and goods. So that's important to say that to you. The Act exempts. Now, this is important. These people don't fall under the Act. The exempts the following transactions from most of its jurisdiction, namely, where the consumer is the state, where the consumer is a juristic person whose assets or annual turnover exceeds a certain threshold. The last time I checked, you can write down there, the last time I checked, that was 2 million rand. That threshold was 2 million rand. You can write in there. And if it has been amended, you can go in the chat group and say the advocate's an idiot. It's more than 2 million rand. It has been amended, and I will accept the title of idiocy then. A juristic person is deemed to include not only companies, close corporations, and the like, but also trust and partnerships, services applied under employment contract, any other transaction which the minister might in future exempt. All right, so those guys don't fall under the Act. And remember, anything under the threshold falls under the Act. So if you're a registered person under 2 million rand, then you will have the protection of the Act. Just understand it in the correct sense. All right. According to the CPA, consumers have the right to suitable quality products. When selling second-hand goods, suppliers often merely cite food stewards, and the consumer is expected to accept the goods as it is presented to them. So if you look at suitable quality products, and you can read the Consumer Protection Act, you'll see the sections talk about this. There's an obligation on the service provider or the goods provider to make certain you get quality products. Suitable, we'll talk about a little bit later. That's very interesting. I want to talk to you about suitable. Underline suitable, we're going to come back to that. Maybe it's in here now. Oh, here it is, I think, if I'm not mistaken. Now, however, the CPA protects consumers' rights by placing specific obligations on the supplier to provide good working goods. There it is, suitable, usable. Do you see it? Suitable, usable for the purpose it was originally intended. So what I want to tell you there is that, for example, I've got a bakkie, and this weekend I want to go with my son to Badplaas. On the Afri trails, there's some nice trails you can walk over 2 days. And if I were to say to the tire place, I need off-road tires that is good in muddy circumstances, this is what this is about. And they say, this is the tires. And I get stuck there in the jungle, and I incur damages as a result of it. Then I can later turn around and say, but you guys are the expert. You said that these tires were usable, suitable for the purpose it was originally intended. In this case, I wanted to go off-road. So this is just a simple example, not the best one out there, but that is what that's about. And this is something that when you draft an agreement, you have to take in consideration, because it's the right of the consumer to be treated in the expectation of this. And you've got to inform your client, because usually the rich guys are your clients. That's the service providers and the goods providers. So please have a look at that. A consumer can, according to section 55 sub 2, rely on receiving good working goods which are usable for the purpose for which it was originally intended. And yeah, I know, if you go in places like witch, not a witch on a broom. If you go on witch, then you order stuff, and especially the watches never work. Yeah, and they are selling it in South Africa. They're selling within the borders of South Africa. And so in that sense, this applies. But it's coming from outside. Luckily, they have good return policy. The exception to this is where section 55 sub 6 applies, which states this does not apply to a transaction if the consumer has been expressly informed that particular goods were offered in a specific condition, has expressly agreed to accept the goods in that condition, or knowingly acting in a manner consistent with accepting the goods in that condition. And that is very dangerous. Don't go there. Don't go there. Always write into your agreements, whether they fall under the Consumer Protection Act or not. Always write in good food stewards clauses there. So food stewards clauses are strictly governed when the transaction falls under the CPA, and it's not really, it's open when it's not, and you'll see later on, but I advise always, it doesn't matter if it's outside the Consumer Protection Act or inside, draft a good footsteps clause in there. And I use one that was recently adopted, not adopted, but approved by the Supreme Court of Appeal in Bloemfontein. I put that one in my property agreements. There is a clause in here. I just want to see when we get there, if it is that one, then you can use that one there. So please don't go to the second points of he accepted the goods in a manner consistent in actions and so on. You can see the holes that one can shoot through there with a double-barrel 12-gauge Maverick shotgun. It is important to note that Section 55 sub 6 only excludes subsection 2A and B, discuss the full meaning that the goods must still be usable and durable. There we go. Durable, underline it. Durable. If I put tires on and just around the corner the fret is off, there's going to be a problem with that. Durable means it's supposed to, within a reasonable sense, last. All right. Many things don't last. So there's a reasonable expectation on that. And then, of course, sometimes you get warranties and guarantees on that. And that's also something we can use in determining that. And durable for the purposes which they were intended and comply with the Standards Act. Now, there you have the first act apart from the Consumer Protection Act that is applicable to this or any other applicable legislation. Thank you. Please turn your camera back on. Oh, guys, do you want to see my face? Really? Do you want to see my face? She says I must turn my camera back on. You know what I'm going to do, guys? I'm going to turn it off because it is on. I'm going to turn it off and then I'm going to turn it on again. And now, all right. Okay, now I've turned it off. Okay. So it was on, maybe just a glitch there. Now I'm turning it on again. All right. According to my system, my camera is on. But guys, don't worry about this. If you cannot see me, just listen to my voice. There's not much to see. Over 50 and on the downhill trail. That's why I want to go walk trail so the trail can go upwards again. All right, guys, it was on, so I turned it off. I turned it on again. According to my system, it's on. Somebody sent a note, turn your camera back on. If it's not on, I've turned it on. Don't worry about it. Listen to my voice. If you can hear me and you can see what's on your screen, we're good to go. All right. Now, where was I? Oh yes, that's where I was. The Standards Act. So I was saying to you, there's the first act apart from the CPA. You're going to see much more acts here. If the requirements of subsection 56 sub 6 are met, the requirement that goods are reasonably suitable for the purpose for which they are generally intended and are of good quality and good working order and free of any defects will not be implied in the contract in the event that the consumer has been expressly informed that the goods are often in a particular condition and the consumer has accepted the goods in that condition. Now, the only thing I want to say here is a lot of people will tell you, no, you cannot sell food stewards goods anymore. You can still sell food stewards under the CPA. You've got to do it in this manner. You can still sell food stewards if it's not under the CPA. Well, that's an open-ended situation. All right, another thing I want to share with you is I've picked up, it's interesting, patent defects and latent defects. And this is very interesting, especially if you sell houses. And I found it very interesting. Senior colleagues of mine would say, what is the patent one again, the latent one? They say, no, but one is visible and one is not, you cannot see it. It's difficult to see. The result person would not see it, something like that. So I just want to teach you what patent and the latent defects are all about, because in practice, I've seen it 1,000 times. People that's been tracking for 10 years must slip their mind and they ask. So here it is. Before we get into the meat of a sale agreement, let's understand two important terms. Patent defects are those that can be easily identified on inspecting the goods, like a broken door, damaged tiles, cracked mirror and windscreen, and so on. All right. So latent defects, on the other hand, are hidden or non-obvious. They would not have been visible or discoverable upon inspection by the ordinary purchaser. Think, for example, of seasonal roof leaks, broken underground drains, leaking geysers, and the like. Now, it's not only the purchaser. You must understand this correctly in the latent defects. It's also the seller. Most sellers don't know that the roof is leaking, except it's going through the ceiling. And most probably it's maybe just something that's not yet gone through the ceiling. So this can be to the benefit of the seller too. And that's the whole thing about patent defects and latent defects. You must understand it in the right sense. If it's a latent defect, it cannot be seen. And then one needs to start asking the question, who's liable for that? All right, so that's very important there. In terms of patent defects is where the buyer cannot turn around and say, hey, stop the bus. That was a broken tile. I want to replace it. He said, but you walked through the house, or you signed that you don't want to walk through the house, because that happens too, especially if you buy on the electronic bank auctions. I've done a few of them to my regret. Then you have that problem. So depending on the argument in court, it will depend to whose benefit patent and defects and latent defects can go, and some of them can shockingly go to the side you would not expect it. If anything you buy fails, it turns out to be defective or unsafe, you can return the goods to the supplier without penalty and at the supplier's risk and expense within 6 months of delivery. I've done a lot of vehicle cases with the ombudsman on these 6 months of delivery, but I have to admit, these ombudsmans on vehicles I don't have faith in at all. You can require the supplier to give you a full refund or to replace the goods or to repair them. The choice is yours. The supplier cannot dictate your options to you. Please take note of that. And again, you can be educational. You can draft this into your contract. I do. Then everybody knows it. Because a lot of people with sale agreements, they just think I sell and I buy, and that's the end of it. And like I said, people don't pay attention to what can happen in a sale agreement. So I like to be educational in this sense, to put out this indemnification and these rights and all of those things. But does the CPI apply to all sales? Aha. Here's the rub for buyers. The CPI applies only when the seller is selling in the ordinary course of business. So generally, private sales will fall outside its ambit. In other words, if you buy a mover like a car from a trader or a dealer, the CPI applies and overrides the voetstoots clause. Now, you can still do it. Am I right? You can still do it, but then you're going to have to follow the CPA guidelines to set up the voetstoots clause. But if you buy from a private seller, the voetstoots clause applies and you have no CPA protection. Please remember, if you buy under the CPA, you can use the voetstoots clause, but you must draft in there in the greatest of details what is wrong with that thing. All right, so please be careful with what I'm saying here. Do not misunderstand it. Cover yourself by disclosing any defects you know of the buyer. Record any such disclosures in a written and signed annexure to the deed of sale. A buyer cannot complain if you have informed of the condition of the goods and have been bought on that basis. Then if you are selling in the ordinary course of your business, be very aware that the CPA applies to you. Understand its very strict requirements and the risk of not complying. If on the other hand you are a private seller, make sure you are covered by the properly drawn voetstoots clause. On the off chance its validity is challenged, you can avoid later disputes with a belt and braces approach. Have the goods checked out and by independent expert like a home inspection service when selling a house, and have your lawyer incorporate that into the sale agreement. Do you see? Lawyers must draft sale agreements. They are complicated. It's not just like I'm selling this broom to that person. That's the end of it. Maybe that broom cannot fly, and then you're in trouble. Section 49 of the CPA provides that any notice to consumers or provisions of a consumer agreement that purports to limit the risk. Listen to this, you cannot do this. In understandable English, you cannot do this. Limit the risk or liability of the supplier or any other person. So the supplier says, I'm not liable if it breaks, if it's cracked or whatever. Constitute an assumption of zero liable by a consumer. Never, you cannot put that on a consumer. Impose obligation on a consumer to identify the supplier or any other person, of course, or be an acknowledgement of any fact by a consumer. So you cannot do this, except if you do that. How? How do you do that? Didn't I explain it to you last week? I'm going to explain it to you again. What I usually do, if I have a clause like this, now please, you must understand something. There is unlawful provisions that cannot go into an agreement. They're in the act. This cannot be of that. These are things that cannot be in an agreement, but are not unlawful provisions if they're in an agreement, but they cannot be in agreement if they're not done in a certain manner. So what I usually do is I put a bold line around that specific clause. Remember, it cannot be an unlawful provision. I make it light gray at the back. I make the print bold. And then I put in the initials of the service provider and the consumer or the goods provider, and the date and the specific time they are signing. That's how I do it. I build it all in there. And when they have something like this, provides that Section 4 provides that any notice consumer provision agreement that purports to may be drawn to the consumer's attention in a manner that satisfies those requirements under 49 sub 3 and 5. And that's how I do it. So you cannot do these if you don't do that manner, but don't be confused there is unlawful provisions that doesn't fall under this. You can just not do them. What did we call that previously? You cannot contract out of the Act. That's what that's all about. So please understand this in the right context. Section 49, sub 3 of the CPI provides that a provision conditional notice must be written in plain language. Yeah, no, I'm not going to talk about plain language anymore, but it's in the Act here. All agreements must be in plain language. That's the direction the world is moving into. And I like Latin, but then you have to really expand on your interpretation division. And section 49, sub 5, the supervisor, the consumer must be given adequate opportunity in the circumstances to receive and comprehend the provision or notice. So please have a look at that. All right, guys, that's it. Now you would say, but that's short. Well, let's wait. Not going to shock you yet. Drafting a sale agreement for a movable property. Okay, let's see. This is a movable. Now, guys, what does the word movable means? All right, here it comes. It's very difficult. It means it can move from one point to another. I know, seriously difficult. Okay. Immovable, I cannot put in a wheelbarrow. Movable, I can put in a wheelbarrow. All right, that's not going to work for me. A car, I can move from one point to another point. And then, of course, we have these park homes. They're on blocks, and you can move them, and then you have court cases on those things. And there's good case precedent on that. Movable, I can move. There is no way I can move my farm. There is no way I can move my erf in a residential area on which a brick house is built. That's an immovable right. I know, it's heavy, eh? All right, heading of the contract, there you go. These will always have subheadings when I do them. The parties, the agreement to the whole contract. I just want to say that, make a note there. In case you have forgotten agreement to the contract in whole, that is where you say the aforementioned parties agree as follows. Double point in bold. That's it. That's what that means there. People don't have it in there. There's court cases where you pick up problems. Index, if applicable, most sale agreements is usually short, except if it's brand new stuff, then it can actually go a far way. Preamble, built in there, what's happening, just something short there. Interpretation, use that there. Specific terms of the contract, purchase, orders, payment, delivery, ownership, risk, warranty, indemnity, branding. Prohibition of set-off, security, consumer documents, propriety rights, credit, exchange rate, National Credit Act, which actually the National Credit Act should actually shift. That should come under the legislative clauses. Let me make a note there. I want to change that, although it's clear what's going on there. Let's stick with what we are saying. Am I right? So do you see it's not that easy? So let me just make a note here. I just want to change this for them. And maybe in a week or so, just update this guide for them again. Common terms, there's your boilerplate terms. Let's have a look. Whole agreement, yeah, variation, yeah, relaxation, oh, that's good, breach, covering law, joint, several liability, severability, confidentiality, execution of contract, counterparts, annexures, and we go to the end there. All right, that is a sale agreement for a movable. Now, buckle up. Now we're going to talk about the sale agreement for a immovable property. This is difficult. I've really seen a horrendous contract goes through the deeds office and the conveyancers dealing with contracts. And I personally think if the deeds office were to become legislatively strict, that a lot of these deals on the foundation of the contracts itself will not even go through. But I've seen horrendous contracts that doesn't comply with the law at all goes through the deeds office. So yeah. All right, let's look at the essential terms. That's the essential law. Seller also comply with FICA. There you have another act. Buyer also comply with FICA. So we've got Standards Act, Consumer Protection Act. We've got FICA. Where the buyer is not reflected in the deed of sale, the deed of sale does not comply with Section 2.1 of the Alienation of Land Act. Look at that. Such a deed of sale cannot be rectified. And you can look at 2013. Osborne and another versus West Dunes Properties. There they deal with that. Have a look at that. You got to describe the property. What is the purchase price? And you got to talk about the sale in general. Further on price. How? When? Including details of deposit. Where? Interest payable. If so, what rate? Is price to be secured? If so, how and by who? What deposit is to be paid? Tax on the purchase price. Determine whether it's a sale of land as a capital asset or whether the profit will be taxable. Usually it's a capital asset, but see, Commissioner of SARS versus Founders Hill, and that's 2011. So we're happy with that court case. VAT or transfer duty, never both. Hey, guys, look at this. VAT or transfer duty, never both. Who should pay? Should a price be adapted to provide for it? Is a zero rating possible? Then we move on to our suspensive conditions required regarding. This is a sale agreement for immovables. How's your offer of purchase looking currently? Where's the conveyancing that's on course now? How does it look? Do you make provision for these things in your agreement? Are suspensive conditions required regarding financial assistance? Why? Is it going to be a bond? Is it subject to a bond? A vacant occupation, rezoning. Did a court case in George on that one. And in the beginning of the year, a court case that ran for 12 years. We were 5 years on it, and we just won it. Rezoning. Subdivision of agricultural land consent. It is a criminal contravention to be part of a sale of agricultural land which has the effect of subdividing an agricultural property before obtaining a consent. A sale or advertisement to sell such a portion before obtaining the consent is invalid. Subdivision of agricultural land, then section 3. How many acts is that now? We already arrived 5, 6 acts on a sale agreement. As the act in section 1 defines sale to include a sale subject to a suspensive condition, the contract drafter should not encourage parties to conclude a sale of an undivided portion of agricultural land subject to the consent of the authorities or the minister being obtained. Even the granting, now listen to this, this is interesting, even the granting of an option before subdivision has been held to be invalid in 4 Arrows Investment versus Abigail Construction, and that was 2015. That's like yesterday. There have been amendments proposed to this legislation, but they're not there yet, so you cannot do it. One should remember that where subdivision consent is to be sought, the undivided portion of agricultural land will have to be surveyed and measured. And there's other aspects that's also relevant there that you might want to draft in there. What about a transfer? When? Who is the conveyancer? Is the conveyancer on the roll? All of those things. If one acts for the buyer, one should consider whether clauses should be inserted to indicate that the conveyancer is the agent of the seller and that the payment of purchase price to the conveyancer would be regarded as payment to the seller. The very interesting case there in 2013, Minister of Agriculture versus CM de Klerk, where the conveyancer had misappropriated a part of the purchase price. The court held that it was a question whether or not a conveyancer was the agent of the seller for the purposes of receiving the purchase price. Where's my young conveyancers now? Did you know that? Did you know about this court case? Having regard to the wording of the contract, the court held that he was the agent of the purchaser, the minister in this case, and not the seller. In Norkie versus Farke 2013 at paragraph 8, the court had accepted the decision held in Basson versus Remini and another in 1992. So 2013 agrees with 1992, which is before 1996, which makes me happy. It's the type of court case I want to read. That ordinarily the conveyancer acted as agent of both parties, the buyer and the seller. The latter case was referred to by the minority Minister of Agriculture versus CM de Klerk matter. All right, going on there. This is interesting stuff. Do you see why it's important to also, when you work with a conveyancer, it's maybe a good thing to build a clause in to say, but I am in this capacity. I'm acting for these people or only for this person. Can you see that when you draft a contract, people tell you nowadays, you mustn't draft too much in a contract. Now, I agree, you mustn't be stupid. You mustn't draft stuff into a contract that's irrelevant. But at times that contracts are short, living in the modern world with his cooperative and fundamental rights in all contracts you can imagine, with new legislation being pumping out and out and out in the world, into the countries, as we're going into space also, contracts are getting longer and longer. There's no stopping it. So I'm one of the guys that rather research everything. So you cannot come to me and ask me, hey, quickly draft me a 3,000 rand contract. I'm not your guy. It's not going to happen. On the nature of the work reserved for a conveyancer and the protection of the public, see Proxy Smart Services versus Law Society of South Africa, where the role of the conveyancer was reaffirmed. Application for leave to appeal against the latter was dismissed in December 2018. And I mean 2018. So if you are a conveyancer and these are the contracts you are drafting, surely you must read this case, because this has to do with who you are. The product you are, in terms of your service delivery, you're producing on your table for your clients. So please have a look at that court case or ask me to send it on to you. And there goes the fingers on the keyboards again. I'm going to work my half to death with all the questions coming through. You've already been warned last week. Cost, who is liable, when due, occupation, when, how vacant or occupied, payment for occupation. I'm very upset. I can tell you something. I've just sold one of my houses. So the conveyancer says, okay, you can give notice, a month notice to the occupant to move out. So we give the occupant notice because she's confident that she's going to register this. I'm 3 months down the line paying the bond installment on the house out of my pocket. Yesterday I said to this conveyancer, we're going to deal with each other. Who's going to pay that money? This is due to your negligence. You instructed, you said, get him out, this is going through, and now there's a problem. So these are the things that happen with conveyancers. Actually, I must admit, my heart goes out to them. They've got a very difficult job. I don't want to be a conveyancer. It's a very difficult job. I've seen people scream at them and abuse them and so on. I just personally think my conveyor is negligent, but I've seen good conveyancers that really gets the wind from the front, and it's not their fault. And then, of course, you're stuck with the service delivery of government. You cannot really promise people anything. Something like that. It's actually better to draft in a contract that an occupant will stay on a month after registration. That occupation rent will go to the new buyer, and then hopefully you don't get an eviction that he becomes a squatter or something. So these are the things you have to contemplate. I'm not very happy what's happening in my deal currently, I can tell you that much. Risk, benefit, who has it when, duty to insure against loss. Think about these things. And now, there it is, footsteps, defects. In 2013, in the case of Banda and Honor versus Van der Spey and Honor, the court held that a leaking roof was a latent defect which rendered the house unfit to live in. Now, that was to the benefit of the buyer. I also had a case like that. I just don't know if the client took it any further. They bought a property for 3.5 million in Johannesburg. And that's precisely what I did in the Particles of Clay. Precisely what that court case is saying. So I don't know what happened there. At the end of the day, they moved on. And the attorney of record moved on, because meaning that the advocate gets on his instructions sidestepped. If the attorney of record is gone, the advocate leaves too. See, Heaviside versus Hydrix and another in 2014 for a recent case where Fusus clause was regarded as providing a valid defense. The clause upheld in that matter read as follows. All right, guys, here goes. The property is sold, foots to it, and as it stands with all defects, whether latent or patent, that's the important thing. You want to cover both. There you are. Subject to all the conditions, burdens, and servitudes referred to in and or registered against the title deeds of the property, and to all such conditions, burdens, and servitudes which may exist in regard thereto. The purchaser is deemed to be fully acquainted with the property nature. Deemed. Do you see the word deemed? Its conditions, beacons, extent, and locality. The seller and the seller's agent be entirely free from liability in respect thereof. And this clause goes and covers the agents. Do you see that? That you pick all these very important little things up in drafting skills as I move through this clause. Very good clause, and that's a clause you can use. The CPA would not apply to a transaction if the goods were not rendered in the ordinary course of the business. The definition of supply in section 1 in relation to goods is limited to such goods supply in the ordinary course of the business. I'll say something about this now again. People misunderstand this. This excludes a once of sale by a person which is not its usual business. See also there and there and there in the rebus. And I'm mad about the rebus. I tell you, I read everything that comes out of it. The CPA will not apply to a transaction of goods were not rendered in the ordinary course of business. See it in the right context. All they are saying there is that if that is the case, you've got to list precisely what's wrong with it, all right? Because people sell second-hand goods in the ordinary business, trader vehicles. So please understand it for what it is. You're going to talk about fixtures and fittings. I see people muck up with this. Repairs, sold boards. A lot of people don't want them in front of the house. Irrevocable offer. Well, you're going to decide what you're going to do there. Competing more favorable offers. You're going to, that's a clause also you can build in there. Sometimes that clause is very unfair. Agents commission. Please just don't muck around with the agents. Please don't muck around with the agents, and be careful of breaching them out of your firm, breaching their commission. Domicile executandi always is a wood boring or damaged beetle certificate required. There you have to look at the different provinces. Make a note there. You have to look at the different provinces, guys, because in some provinces it are and others it's not. Deal with obtaining electrical safety compliance certificate, also electrical fence compliance certificate. There you have it, in case you didn't know about that electrical fence compliance certificate. You don't want people touching a fence and dying, and you didn't have a guy out there that says it complies with it, because, you know, kids run around, kick balls and play. There's one of the many reasons why you need to do things like that, and you'll find that under the Occupational Health and Safety Act and the Electrical Machinery Regulations referred to in Government Gazette, so on. So there's another act, sale agreement, another act. Deal with other certificates required by the local authorities, like in Cape Town, the city requires compliance for plumbing and for gas. How about that? Common terms, that's the boilerplate terms. Let's have a look at them. Whole agreement, yeah. Non-waiver, yeah. Jurisdiction, sure. Domicilio executandi, which is service of address, yeah. There's your ADRs, which is your negotiation, mediation, arbitration. There's all applicable law. Man, we've actually now showed you how many acts is relevant. Interpretation and definitions, etc. The list goes on. All right. How will it be dealt with regarding any existing other rights over the property? One of the places you can see this is usually registered at a deeds office over the property, right? Current mortgage loan, option van Aert versus Galway 2012. So we like the year. It's almost like good wine. The seller was not allowed to escape the option on technicalities or as a result of the impression that an option required for a negotiation or agreement, they ruled there. Right of first refusal, check the source of such a right. So as you can see, you can go to the deeds office, but most of these rights you will not find at the deeds office. If there is such a right, it's contained in a valid agreement. If not, it's unenforceable. Verster versus Fletcher and another, that was 2012. In the context of a sale, a right of first refusal, also known as a right of preemption, voorkoopsreg in Afrikaans. In this regard, see Bix and others versus Muller and others, 2005. Wine might not be so good, but it's after 1996. Where a preemptive clause in a contract considered stipulated. The lessor grants the lessee a right of first refusal in respect of the property, and the lessee, upon an offer to purchase having presented to him in writing, will have appeared in 14 days to match such offer, whereafter a deed of sale will be constituted on the terms and conditions as agreed to by the parties at a time. I'm not very mad about this clause for a couple of reasons. One is 14 days. I don't like that. And also, if I talk about days in my interpretation division, I will say what type of days it is. Does it include weekends? What's going on there? And usually under the National Credit Consumer Protection Act, they'll exclude those. And then, of course, it says there, well, to match such offer after a deed of sale will be constituted. That means it's going to happen. So there's a couple of reasons why I think this can be dangerous. So just have a look at that, see if it works for you. If it works for you, use it. A couple of things I don't like there. There's a lease agreement. You can write beside that lease agreement, hier gaat voorkoop. Hier gaat voorkoop. You can roll with it like that. And then servitudes. Now, actually, when I spoke about a deeds office, I spoke about servitudes also, amongst others. At a deeds office, there might be an interdict, that might be other stuff you want to have a look at. Servitudes that runs through there. Maybe there's a servitudes on the property. So when you buy it, you're going to have to accept that. Maybe people don't want that. I don't know what I want to do. Farms and residential properties all can have servitudes. Most do. Have necessary consents been obtained from the authorities? Let's have a look at that. Some local authorities require advance payment of rights on the property prior to granting clearance to transfer. There is then usually a refund sometime after the transfer of ownership has been registered. Such refund should be claimed by or on behalf of the seller. The mechanism set out to serve the Local Government Municipal Systems Act, which gives municipalities a preferent claim, debt collection process for arrear rates and service charges does not survive the transfer of ownership. Yeah, I'm so happy about that court case. That's a very well-known Jordan court case of 2017. Because they used to keep you liable. And in 2017, while I was busy with cases, also similar cases for a big conveyancing attorney in Johannesburg, and this was a big problem. Somebody went and this court case, they say, no, historical, they right down there. If you ever want to Google it, they call it historical debt. They said, and they ruled in this manner. This was excellent. There's a good court case for you. And if the conveyancer, you don't know it, there you go. Guys, Homeowners Association, Body of Corporate, please attach their rules, everything about him to the deed of sale. Just do it. Just do it. I know sometimes they think I used to draft them. Sometimes they're 200-300 pages long. Sometimes they're 40 pages long. Please have a look at those things and attach them so that when a property is sold, the person buying knows about this. In any event, you won't be able to sell if you don't get necessary certificates there too also. Members holding 75% of the members' interest in writing, where the buyer or seller is a close corporation in terms of Section 46 of the Close Act, then you need a resolution. Have a look at that. Shareholders by way of special resolution, if it's a company selling or bonding the property and the property forms more than half of the assets, that's more than 50%, the company in terms of Section 112 and 15 of 71 of 2008, that's the new act, then you have to look at that. You need a special resolution, attach that special resolution, because that's your authority. However, as to bonding, see Stanenberg versus Hunky Dory Investments of 2010, where the court held that a mortgage bond is not disposable for the purposes of the old act. And they still spoke about the old act there. And that status quo has been retained until we get something new that comes out of it. Is the purchase price $250,000 or less? Cooling off clause in Section 29A of the Alienation of Land Act. Have a look at that. If the seller is a trader and land is an asset of the trader's business, see the narrow definition of a trader, McCarthy Limited versus Gore 2007. But beware of the consequences of Gainsford and others N&O versus Tifsky Property Investments. That was in the appeal court in 2012, which had the following result. So you need to pay attention to this when drafting. You need to mitigate the risk. Has the risk of criminal liability for not advertising been explained to the parties? There we have the Insolvency Act. How many acts do we have now? Do you see where I'm going with this? When you deal with a sale agreement, specifically under immovables, let me qualify it, because you might say, but it's not that bad on the immovables. Regarding Section 4 of the Insolvency Act, adverse, in terms of adverse, does the contract stipulate who will place the adverse in a government gazette? Afrikaans newspaper circulating in that district, English newspaper circulating in that district. Does the contract stipulate who will pay for the adverts? By when must they place to comply with Section 34 between 60 and 30 days before disposal? Allow for government printer requirements regarding cost on Friday or other day before advert is to publish. Take that into consideration. Does the buyer know of any proceedings instituted against the seller? This is an important one. I had many cases now where people lie about this. If so, what safeguards has been introduced to prevent creditors of the seller from attaching the bid in terms of Section 34 free sub A, sub 3 sub A? If not, at least give affidavit from a seller stating that no proceedings has been instituted in the High Court or Magistrates Court in whose jurisdiction the business is conducted. Please make a note here. I've had a couple of these cases. Please make a note that in every deal you get an affidavit. In every deal you get an affidavit, guys. And please, don't write in your affidavit only High Court and Magistrates Court. That's nonsense. Write there any court. Just cover it in basic court. Don't go there. Say any court, also jurisdiction. If not, at least get affidavit from the seller starting no proceeding has been instituted in the High Court, Magistrate Court, in whose jurisdiction the business conducted. Take jurisdiction out there. Take jurisdiction out there. Make it general and use the word any official court in South Africa. That's what I'm saying. Take that stuff out there. You don't have to do it. You can. There's a lot of senior conveyance misprice shouting, but what are you doing? Think about what I'm saying. Think about what I'm saying. Take it out of there, but every deal, put an affidavit in there. Set a template up, like a template, and deal with it in that manner. Have the following due diligence steps been taken? Due diligence, before we talk about due diligence, you get basic due diligence, and then you get what I call forensic due diligence. When you sell businesses, big corporations, then you do a in-depth due diligence. Let's see what I say here. Do these officers to verify seller description and interdicts on property. I'll never get caught with this. I don't do contracts without putting every kind of verification I can find, because I've had fraud committed. People saying they own things and they are directors and they're not anymore. How will any expropriation X or other encumbrance or indirect notes be dealt with that these officers reflects? You've got to know where all of that is going. If buying from a deceased estate or from someone who bought from a deceased estate, has there been proper compliance with the requirements of the Administration of States Act? There's another act. Section 42(2) requires that an executor desires to effect transfer of any movable property, lodges with the registration officer, amongst other things, a certificate by a master that no objection to the transfer exists. And you can contact Merlin September if you want to. We're going to attempt. Listen to me, I'm saying we're going to attempt a deceased estate course shortly. Not wills. Wills is on its own. I'm talking about this, the administration of deceased estate, and see if on a webinar we can do it to such a degree that you can learn a lot from it, because there's calculations and stuff there. And obviously we're not sitting in a venue where I can see the confusion in your eyes. So we just move on, explain it and move on. Let's see what happens with that. If you want to join it, get in touch with them to that regard so we can fill up those seats there. In Nedbank Limited versus Mendello 2013, NO Nomio Officio. Those guys who doesn't know, Nomio Officio usually refers to trust. The court confirmed the setting aside of a transfer where a master consent had been obtained as a result of a fraud by one of the sons of the deceased. All right, there's a court case for you. If you are buying from a seller who bought a property at execution sale, check the summons. I did it, bought 2 properties on an electronic auction from Nedbank. Not my best day ever. Not my best day ever. So yeah, more trouble than it's worth, I tell you that. If the sale was in respect of a mortgage bond foreclosure, did it have the endorsement warning to the defendant that the owner might infringe their right of access to adequate housing in terms of Standard Bank of South Africa versus Anderson 2006 in the appeal court? Always look where your court cases are. Are they in the higher courts, the superior courts, or in the Supreme Court? I love superior courts. Your Supreme Court of Appeal, that's the one we want to look at. If granted, or the constitutional courts, obviously, logical. If granted by default judgment, was there proper application in terms of Section 66 of the Magistrates Court Act or the High Court before judicial officer? Were all the requirements for the sale adhered to? Yes, it's a mouthful we're going through now. Eh? If no to any of the provisions, the previous 2 questions explain to the parties the risk of retrospective invalidity, and that is the danger. That is in the danger set out in Mengwan and another versus Marcomanas in 2008, as well as Gundwana versus Teco Development in 2011. Guys, you must explain the retrospective ability of these things, because the client can incur serious damages. Right, there's the annexures, always annexures. Your information sheets, your body corporate, and we say that, your agent mandate, and anything else you want to set up there. And that, ladies and gentlemen, concludes today's presentation. And tomorrow we'll take on shareholders agreement. And let's see what we're going to do. Let's see what we're going to do. We're going to do shareholders agreement. Always interesting. Actually, very difficult agreements. Shareholders agreements and selling of shares. We're going to do association agreements. Talk about some interesting facts there. A lot of people always think association agreements is something wild, but it actually only pertains to close corporations. Did you know that? Then we're going to talk about leasing agreements and all the things that's happening there. Leasing agreements, borders on constitutional rights, evictions, etc., etc. So they need to be done right. And I think those are the, and then we are going to end up off with the non-disclosure and confidentiality agreement. And we might actually go in that last hour in, half an hour in, tomorrow. All right, ladies and gentlemen, that's me for today. I hope you enjoyed it. I hope you have a better understanding of sale agreements, especially movable properties. And I hope that it empowers you with knowledge so that you put up these products for your clients, you do it well. And that's what's important. If you're in a corporate world, some of the other agreements we've done, I hope you enjoy them and you feel more powerful and confident in first of all, reading them, make certain that your legal representative has done it well, first of all. And also, you can also work on them yourselves. All right, guys, I'm out of here. I'll see you tomorrow for the last time. Same place, same date, same time.